I had mentioned last time that that you'd have off the Wednesday before break, but that's been changed. It turns out that the doctor that was going to do my hip replacement tore his bicep on Monday and is not going to be able to do surgeries until January. So we will go ahead and have class on the Wednesday, the 7th. Yeah. So anyway, just for your information there, you get your class day, so you get your full tuition here. All right. I also put 2 old exams in the ECON 472 folder. So you can take a look at the first midterm that I did in, I think, fall of 19 and, I don't know, fall of 17. Anyway, the last 2 times that I did law and economics. So you can take a look at those exams and give you a decent idea what your exam's going to look like. All right. So when you're applying for a patent, we were talking about patents last time, and when you're applying for a patent, you need to have 3 basic things about it. One, it can't be too abstract, okay? So if I want a patent, it can be not too abstract. When they're trying to, when you're trying to get a patent. It can't be a natural discovery, although that had a little bit of a change. That is, it can't be, I get a patent on a fish that, there's a new fish that's floating around here. I can't get a patent on that fish. So if you were to, use that fish at a restaurant or something, you'd have to get, permission from me to do that. And you need to define the scope of what the innovation is. Like if you have a drug, you have to say, here's what this drug is there to do. Here's the application. What sort of disease does it treat? All right, so last time we talked a little bit about the duration, and we're going to just use economic theory again, just to think through what would be the optimal patent life, right? So if we're looking at duration, to sort of think through it, what's the optimal length of the patent? We said that patents generally have a 20-year patent life. It turns out that there's some things called design patents that are shorter, but basically we have a set length of patent out there. But if you looked at the benefit to society, we said there's this cost to society if you have a patent that's not going to be distributed as much, but creates an incentive for innovation. So what's that trade-off? Well, if you thought about it, you'd have different patent lengths. I mean, if you really were to do it, very efficiently, you'd have different patent lengths, right? If you're going to do it optimally, you'd have different lengths depending on what if there was a lot. For example, what if you could generate a lot of revenue at the beginning, right? So there'd still be this incentive to innovate, even though you knew other firms were going to enter. If there was if there was lots of profit in the short run, then of course you'd have a different patent length. If you had what if somebody was going to stumble across it anyway? Like maybe in a couple years it was going to be, someone was going to come across it. It wasn't something that was highly innovative. So maybe would someone have discovered it anyway, or shortly? Would someone have discovered shortly, like in 2 years or something? In those cases, what would you do? You'd have a shorter patent length. So you might want to look at that different costs and the different benefits, and have the patent length differ. But then what we say, we said that there were 669,000 patent applications last year, right? So to go through each one and figure out, okay, I think that, we're at the patent office and we think this is something that people could earn a lot of profit from in the short run. We'll assign a shorter patent length to it. You can see that the mechanics of actually applying this rule might be rather difficult. Again, you might have major discoveries that have lots of value. You might want to give if you had something, hey, we want to figure out this drug to cure COVID. We're going to give a high or a long duration of patent length so that you can earn profit over time with that. So again, there's just sort of things that you can think about in terms of looking at the benefits and costs. In Germany, you have to pay an annual fee to keep the patent. So that sort of gives you an idea how much does the person that owns the patent value the extended length in the patent. And so you could do something like that. If you have too broad a patent, then you could discourage innovation. And in particular, this has to do with the pharmaceutical industry. If you have to use an existing drug to discover new uses or develop a new drug, generic drug or whatever, well then, if you have a broad patent, the problem is I have to go out and get use of the patent. I have to maybe pay somebody to use that patent in order to develop this new drug. And so if you make the patent too broad, you might actually end up discouraging innovation. And in fact, there was the what's called the Waxman Act in 1984. The Waxman Act in 1984, it set it up so that you could use patented drugs for the development of a generic drug or for new drugs. And so that was there in order to encourage innovation in the development of new drugs that required the use of an existing drug in order to create that new innovation. Other thing to think about is what can be patented. Right? What sort of thing do you want to have patented? For example, could I patent a business method like Henry Ford in the factory, in the factory system? Can I patent this particular method of doing business? What about gene therapy or gene fragments? Prior to 1980, you had that life forms could not be patented. You can't patent life forms. But then what happened in 1980 was that there was a 5-4 U.S. Supreme Court case. It was called Diamond versus Jack Roberty. See what else? Make sure I get this spelt right. Jack Roberty. And this was a 5-4 decision of the Supreme Court where it said that genetically modified or genetically engineered bacteria were patentable. So even though it was a life form, it was, the idea was, well, it really didn't exist in nature, and so you guys have created this new life form, and so that bacteria could be patented. And it had to do with developing oil, a thing to dissolve oil and it was a microbe. But anyway, so that's an interesting question. What can you patent? Okay, and so again, for using economic analysis, you'd want to say, well, I got to look at the benefits and the costs, right? If I give this patent out there, is that going to increase the amount of innovation that's going to happen? Could I buy a patent in order to keep other people from competing with my product, right? So I got this product over here. Do you have a patent that's got a product that's similar to mine, but it's sufficiently different that they were granted the patent? Could I just go around and buy up patents in order to keep people from using the patent to develop competitors to my product, right? So maybe that's that's another thing you want to do. Do you want to make it so that if you don't use the patent within a certain period of time, that it goes away, right? I mean, that's one way that you could deal with that. Does that want to? Do you want to deal with this issue of why people might be buying up patents in order to keep others from competing with them? So, last sort of point on patent is that, again, information is like a public good. We talked about that last time, right? Difficult to exclude, non-rival in consumption, everybody gets the same amount of it, and it'll generally be underproduced, but it might not be. If you figured out, let's say you figured out a way to forecast rain, then what you might do is you might be able to buy futures in wheat, right? You could find a clever way to use your information in order to earn money anyway, and that would be something that people might use. You might buy certain stock or stock in certain companies. Okay, because you now know that this information, you've got this information, you make it so that a company has access to it, you're working for the company or whatever, and then you can buy up the stock in that company if it's going to be to an advantage. There's laws against insider trading. I don't know if you know about that, but there's laws against insider trading where you know something's going to happen before the other people do, and then you can buy and sell stock in that. Last sort of thing is there's what's called network effects or industry standards. That might allow you to gain from innovation without having to have a patent. Network effects or industry standards. And those things will create a natural monopoly. So you wouldn't necessarily need a patent in order to protect the profit from that. So what would that be? If you had let's say there was several applications that you need a operating system in order to be able to use that, then if everybody starts using TikTok and in order to operate TikTok, you have to have some sort of Microsoft operating system. Then that operating system won't need a patent because everybody's going to be using that operating system because it's got the cool applications with it. So that's what, if we sort of think about one of the examples of a network effect is that a telephone, when it was developed, if nobody else had a telephone, the value of you having a telephone is near zero, right? But when lots of people have telephones, then that value to you of having a telephone is going up. And so that's what's called network effects. And if you go back and look at the history of Bell and AT&T, you'll see that that is a major factor in the telephone industry and why you had basically telephone monopolies that were developed. I mean, there's other things that happen from a public choice perspective, but the bottom line is that things may not need a patent in order for certain types of innovation to occur. Now, another thing is copyright. And copyright is where you get property rights to an original expression, okay? So you get rights to an original turns out you can't copyright a title. So somebody else could use a capitalist manifesto, and that would be there. I don't have a copyright to a capitalist manifesto title. I have a copyright to the book, but then the question then is same issue of, well, first of all, you don't have to register. A patent, you have to register. You have to apply for a patent. Has to be registered. Copyrights, you don't have to register. You just put at the beginning of the book, copyright, okay? Same issue then is the length and breadth, okay? How long do you want to make the copyright and what's the breadth? So we have, just a similar issue with the duration, we've been calling it, and the breadth of the copyright. Currently, it is the life of the creator plus 70 years. So, if I die, possibly that could happen one day. And if that happened and my wife was living, then the estate, she would be able to use the copyright, right? So if anybody wanted to use my book, they would have to get copyrights, and I could sell it to them to allow them to produce it, whatever. Now, so again, this is 70 years plus the life of whoever receives the copyright. Now, the breadth of it. Anybody ever heard of Weird Al Yankovic? Okay, so what happens? Weird Al uses regular songs, right, and does a satire of it. Question is, can he do that? Right? Do you allow people to use it for a satire, in fact? For the ECON 105 class, I played, some of you had 105, right? So I had that Tom Petty song, the refugee song, right? And then I have a slideshow that goes with the refugee song, and it plays for about a minute. And so we did that, or Dr. Butters, videoed that, and of course, what happened was, and we put it up on the YouTube channel. They have a different YouTube channel for the 105 lecture, and got a notice from whoever holds the copyright to that song that we were using that song and we had to take it down. Now, one thing, the question is, can you do this? That is that, can I have can I use it for educational purposes? Right? Or, as I said before, can you use it for satire? Or you guys have probably heard of sampling, where you take part of the song and you play around with it, disc jockeys and do that. So that's what's called the fair use doctrine. Can I go ahead and use it anyway? So the fair use doctrine would allow you to do that. Now, that would have required Dr. Butters to get a hold of the people that have the copyright to the Tom Petty song and explain to them what we were doing, etc. So we're not quite sure if that's what we're going to end up doing, or just the easiest thing is just for him to take the sound off of that. But if we wanted to, we could probably get a fair use doctrine use it because it's for educational purposes. So anyway, what do you want to do with this copyright? If you're going to expand the state of knowledge, then or add to entertainment, maybe you want to let Weird Al do a use of this satire of a song. So again, it's a matter of breadth and duration, the same thing that's going on with patent laws. Are some things in a fundamental or in the public domain? That is, for example, anybody heard of Linux operating system? Okay, so it's free, right? It's out there in the public domain, and people sort of volunteer to make improvements on it, right? And I said before, Wikipedia, something where people can just decide that they're going to volunteer to provide information for free. So you could have some things that are out there, what they call in the public domain, and you might think of operating systems like a language and the applied programs like a novel, right? You could sort of think of it that way. So again, it's just a matter of thinking of what's the incentives of the system that you're creating by structuring the law and copyright the way it is. Technological changes have certainly made a difference. That they will affect the optimal length and duration, or optical length and breadth of the copyright. So, for example, the internet changed the way academic journals work. I mean, in the old days, if you go into my office, I actually got rid of a bunch of them. But I had all sorts of old academic journals, right? American Economic Review, etc. And so what did you have? You actually had the book itself, and you had to pay in order to get the book delivered, right? Well, today, you have the magic of PDFs and JSTOR and that sort of thing, where you can, the cost of the academic journal is much smaller now, So the technology has sort of moved it around as to what you're buying when you get into the academic journal. The cost of dissemination is much lower today than it was when you had to wait for the mail and get it there. I mean, you could also think about digital music. Anybody ever heard of Napster? Okay, so Napster is a famous case where it was file sharing, right, in digital music. And that was a famous case where Napster had to stop sharing the music, right? And it went out of business. And so, but today there's a Napster, you know, there is a company called Napster, but it's a new version of it. It's not the same company. But the bottom line is, when this was first starting, the copyright law was used to keep this file sharing from happening. But today, you have all sorts of streaming and, you know, like I said, you can get Spotify with ads, or you can buy the premium version or whatever. So there's all sorts of ways to have the digital music is, you know, looks very different than the vinyl. Could I produce this album that we didn't have the copyright for in vinyl? You know, it was a different system. So again, it's the you have to balance the Pareto optimal issue, right? That is, could I make somebody? Does it make anybody worse off that you're now streaming Tom Petty's Refugee Song? And if it doesn't, if I could make you better off by listening to Refugee and nobody else is worse off, then why don't we go ahead and do it, right? So again, you have this public goods sort of issue with regard to information. So again, bottom line on copyright, you have the same issues you do in patents, length and breadth. Copyrights you don't have to apply for. You just state that you have the copyright. Now, because it's a lengthy process, how do you know that you're violating someone's copyright? Okay, it might be difficult to know, hey, maybe your novel looks a lot like my novel. How different does it have to be? I have to seek through all sorts of information to find out if I'm violating a copyright. You know, is this this guitar riff? Does it sound a lot like this other guitar riff? Right? What's the breadth of this thing? And so again, the administrative costs. There's administrative costs to this, and you have to make that trade-off. Another thing is called trademarks. So you have patent, copyright, and a third thing would be a trademark. McDonald's Golden Arches, okay? That's an example of a trade-off. What it is, it's a brand name recognition. Can you put up a McDonald's Golden Arches sign and call yourself McDonald's, or would that be in violation of trademark? And why, if you sort of think about why that you want a trademark, is that it's a signal of the quality of the product. Now, again, just historically, trademarks have been around in England since the 13th century under common law. But in the United States, the first U.S. trademark is a statutory Trademark Act from 1946. So in the U.S., this idea of trademark comes back to 1946 in the U.S., where we had the Federal Trademark Act. Now, why would I want to have a trademark? It's to signal to you what the quality of the product is. So when you go into Kroger's and you buy canned pineapple, right, there's going to be Dole pineapple and there's going to be Kroger's brand pineapple. And the Kroger's brand is almost always cheaper, right? Or if you go to the Motel 6, right, you know what the quality of the Motel 6 is, right? What their slogan is, we're inside and you're not. Right? No. We'll keep the lights on for you or something, whatever it really is. But, you know, if you go to the Hyatt Regency, right, you're going to expect that when you see a sign of a hotel and it says Hyatt Regency, you expect a certain quality of product from it. Even though you don't know, you know, you're driving through Fargo, North Dakota, you've never been there before, and now you see the Motel 6 and you see the Hyatt Regency, you're going to have a pretty good idea about what the quality is going to be whichever hotel you choose, right? And so that's what trademarks are there for. They're there to give you the brand name recognition. So there's no reason to limit the duration of a trademark, right? If you sort of think about it, why would I want to say the Motel 6, there after 10 years, that trademark goes away? Because you want people to know what this quality of the thing is. And so you want to be sure that we don't limit the access to this information. Now, what about the, like, it's not that you're going to keep another Motel 6 from showing up, right? If I do the trademark, you could open up another cheap hotel and call it something else. And so people would have that information if you trademarked your title of whatever your motel is, you know, that would be out there and people would have that information. So there's no reason to think about the duration. But what about the breadth? Again, patents, copyrights, trademarks are all the two big issues are duration and breadth. How broad do you want to make it? That is, can I trademark aspirin, right? You can go buy Bayer's aspirin, right? You can buy Kroger brand aspirin. You can buy different kinds of aspirin. But aspirin actually was originally developed, right, as a product. But after a while, if it's that you can't trademark a generic name, if it becomes into the common literature, you can't trademark. Okay. For example, Apple, not the computer, but regular Apple. So you can't, or couch, right? You can't trademark the name couch, right? This is a Macy's couch or a whatever couch, or Geltzer's furniture sells, whatever. You can't trademark something that is a couch. And notice that that products can turn into a generic name. The old example was Xerox. Okay, it turns out that there's a Xerox machine, right? But then people started saying you're going to go Xerox something, right? Instead of saying we're going to copy something, you say you're going to Xerox something. Today, what is a name of a product that's now become a verb?
Oh, verb. I was going to say Kleenex.
Well, Kleenex, yes. Kleenex would work, right? People talk about a Kleenex even though it's not made by Kleenex. What do you say that's not, that'd be equivalent of Xerox?
Google?
Yeah, Google. You'll just Google it, right? Well, where did that come from, right? That originally came from Google as a trademark, right? Google was a thing, and then it's now become generic. So now it's probably you can't use the trademark for Google as a trademark name. In fact, coming from California, we used to call all soft drinks were Coke. Do you want a Coke? Oh yeah, I'll have a ginger ale, right? And so that doesn't happen out here. But anyway, the point is that at some point something can become a generic title and is no longer part of the trademark. Could you sell your trademark, right? You can sell a patent, right? You can sell copyright. Now, if you think about it, you wouldn't want to. You wouldn't want to let people sell the trademark because what is it? The trademark is to give you information about what the quality of the product is. And if, let's say the Motel 6 bought the Hyatt Regency trademark and just started, making Hyatt Regencies look like the Motel 6, that would not be what the use of the trademark is for. So if you do, then what has to happen is it has to be produced under the unless it's produced under the supervision of the original holder. Which makes sense because if the purpose of the trademark is to give you a quality, a signal of quality, then that makes sense that if I sold my trademark to somebody else, I would have to supervise and basically it had to be produced by me so that people would know this is the same quality as it was before. So it could also be produced by them, not just under the supervision. We'll say produced by the holder or under the supervision of the holder. All right, so that leads us to the next section, which is organizations as property. So if we look at, we were basically looking at intellectual property, right? Now we're looking at what about organizations as property? Well, how about in the Hudson Bay Company, right? In the Hudson Bay Company, what was that? That's an entity, and what can it do? It can buy and sell things, it can own property, it can enter into contracts. And so what we formed was this idea of a corporation. And the idea of the corporation is that here is an entity that is out to produce profit. Okay? So by putting this thing called a corporation together, what that does is allows for greater production, more profit to move, and to move things from people who value it more to people who value it less. And so what do you have? You can go out and buy Google as a corporation, right? Or you can buy Johnson & Johnson, okay? And so what is the purpose of the corporation? If its purpose is to make profit, then it makes sense that this thing should be owned by the people who are the stockholders. Okay, so that's what they're called, C corporations, and these companies that are in the S&P 500 or whatever. What are these? Their purpose is to make a profit. Who owns the corporation is the stockholder. How many in here own any stock in any company? Okay, all right, a few of you. Okay. So let's say you own stock in Apple Computers. If you own stock in Apple Computers, you actually own part of the company. You are an owner of Apple Computers. Now, if you have 50 shares of Apple Computers and there's 15 million shares out there, then you own a tiny little piece of Apple Computer, okay? But that's who owns the company. You've structured the law so that there is a thing called a corporation, and that corporation then is owned by the stockholders. Now, if you have a nonprofit, let's say there's we create this law that allows for an entity that's a nonprofit corporation. It might be called a 501c3 or whatever. So you could have a nonprofit corporation. But a nonprofit corporation is not out there by, that corporation is not out there in order to produce profit. It's out there to do something else. Okay? So maybe it's the Nature Conservancy. It's not there to earn profit, but it's out there to improve the, the natural environment, or to make it so that animals don't become extinct or whatever. Okay, so that's their purpose. Nonprofits are not owned, but they're governed. So, for example, Hillsdale College, right? Nobody owns Hillsdale College. Okay, there's a governing body that is the board of directors or whatever. There's a governing body that governs Hillsdale College and says, okay, we're going to build this building, or we're going to change the core curriculum, or whatever we're going to do. Okay, so because it's not an entity that's creating profit out there, then it's not owned by the stockholders in the same way that General Motors is owned by the stockholders. You are, again, it is an entity that is created by law, and it exists as an entity. It can enter into contracts, right? It can buy and sell property. It can do all sorts of stuff, but it's not owned by anybody. It's governed by its body. The last point to make is this issue of limited liability. So what limited liability says is that if the corporation owes money or is in debt, okay, then the owner of the stock is not liable. If you bought Pan American Airlines, which I did, and it goes bankrupt, they can't come to me and say, oh, well, Pan Am owed $50 million and it only had $20 million in assets. We're going to come and take money from you in order to make up for the liability of Pan Am. That was an interesting, that was sort of an interesting innovation that says, hey, I'm more willing now to own stock. I'm more willing to become an owner of a corporation if my only liability is the loss in the value of the stock. Now, you might have heard of LLCs, limited liability corporations, or S corporations. Those have limited liability to them. Now, they may not sell their stock in the in the New York Stock Exchange or whatever, but limited liability corporation is a similar feature where we created this thing that said, you know what, if you form this company and you form it under the statutory piece, the limited liability corporation, then your assets are not going to be taken away if the company itself enters, loses money and ends up not being able to pay its debt. Okay? All right. So what we'll do for next time, we're again moving our way through chapter 5. We're going to, for the exam, whatever we get to by let's say the Wednesday before the exam will be where we stop. But again, you can take a look at the old exams and you'll get an idea what type of questions that'll be on there.